Good afternoon. This is Media Center, Ukraine, Odesa. We continue our briefings today. And now we are going to discuss the consequences of the decision of the European Court of Human Rights on the prevention of discrimination in marriage issues. Our guests are Vitalii Matvieiev, attorney, and Ivan Tereshchuk, director of the separate subdivision of the NGO LGBT Association, LIGA. So we will first give floor to Ivan to share details about this case. At the moment, in Ukraine, it is impossible to marry for homosexuals. And Ukrainian homosexual couple addressed the European Court of Human Rights about discrimination when it comes to the right of marriage. And the European Court of Human Rights made a decision that there is discrimination and that the compensation should be paid. But this decision is not a precedent decision for the European Court of Human Rights. A similar decision was in 2023, if I'm not mistaken, in Romania. In 2021, the decision about the situation in Italy, and the range of the decision means that there is a sustainable practice for the European Court of Human Rights. And I would also like to say that this will be the first precedent because the European Court of Human Rights qualified violation of Articles 14 and 8. What does it mean? Before that, the European Court of Human Rights qualified it according to Article 8. This is the right for a private life, and this is Article 14 in Ukraine, which speaks about discrimination. This means that now there is discrimination in Ukraine for LGBT couples that cannot have the same legal relations as heterosexual pairs according to our legislation. So it was scrutinized why heterosexual pairs have more rights and liabilities compared to LGBT couples. Because, for example, when it comes to the military, their partners could not have any guarantees in their home front if, in case of death of their partner in the combat zone. They cannot even take their bodies from the combat zone. There were different strategies and decrees of the Cabinet of Ministers of Ukraine to consider this issue, to provide some benefits and guarantees for same-sex couples. But as of today, we don't have any guarantees. The European Court of Human Rights also considered this issue, and it was stated that due to the fact that this is the violation on the national level, because Ukraine has not done anything since 2015. Ivan, would you like to add anything? I would like to say that the situation with the homosexual people in Ukraine is not that bad as it might seem from the first sight, because for the recent years, the gender identity and has been regulated by several acts in labor legislation, in the regulatory acts of the Ministry of Health of Ukraine, in regulations such as the Code of Ethics of the National Police. So at the moment, we can see some positive trends to change the situation. The Ukrainian parliament has already registered the draft law related to same-sex couples, and that was taken into consideration by the European Court of Human Rights. And at the governmental level, there is now the development of the similar draft law by the Ministry of Justice of Ukraine. All needed changes have already been included in the strategy of human rights. For me, this strategy is rather doubtful because the previous strategy also defined this as the priority for activities, but nothing has been done. We can see now that the situation is changing, and we hope that they will have changes in the future. I would also like to add that the strategy was planned for 2023, so till this year, but as of today, we don't have any regulatory act adopted by the Verkhovna Rada of Ukraine to ensure these rights and also to improve the situation with the discrimination in Ukraine. And Ukraine will not pay such big monies to the European Court of Human Rights. I have two questions. The law on civil partnership, if they're not mistaken, the registered civil partnerships, it has been submitted to the parliament, so it should be considered. Will the decision of the European Court of Human Rights expedite the process? And the question about the court practice, can this decision be used by courts when it comes to the tragic issues like you've mentioned, so for the partners to get the bodies of their partners from the combat zone, it is now impossible, will be possible at least through the court proceedings. The draft law does not settle all the issues that have been mentioned in the decision of the European Court of Human Rights. But this is the first step, the first measure for same-sex couples to have the same agreement on partnership and to have some guarantees. This cannot substitute the family code of Ukraine, which is now in force in the constitution of Ukraine, that clearly says that the marriage is concluded between men and women, and solving some property issues. But the partner could be first in line when it comes to heritage, as other relatives of the first line, like children of the deceased and relatives of the deceased. So it will be the first step that will give us green light to continue our work when it comes to legislative process. And the question about the decision of courts. Before we come to the draft law, I would like to say that the decision of the European Court is quite substantial because we already have the precedents in the Ukrainian court practice when the courts acknowledged same-sex couples as the marriage couple, and I have several cases. One of them were in the Odesa region that was about two women who lived together and were not married. So in the future, the Ukrainian court system can refer to the relevant decision of the European Court of Human Rights, but this cannot affect the legislative base. This can be additional economic leverage for Ukrainian MPs to vote for this draft law. But is it realistic? We will see this in the future. We should also understand that the decision of the European Court of Human Rights is a part of our national legislation. After signing the convention, we should understand that there are higher legal forces, and now we have the decision of the European Court of Human Rights. Could you remind us about the amount of compensation for the 10 years of court proceedings? This is like 4,000 euro. This is the compensation for expenses, and 32 euro, or 32 or 32,000. No, this is 32 euros. This is the compensation for material losses related to the application to the court. That's quite interesting. Thank you for sharing details about the consequences of the decision of the European Court of Human Rights for Ukrainian legislation. Hopefully, we'll be able to invite you here again with in other cases. Thank you.